Good evening, everyone. I'm Harold Holzer. I have the honor of serving as director of Roosevelt House. And on behalf of Ann Kirshner, the president of Hunter College, I want to welcome you all for an event that I think falls under the category of an embarrassment of riches. Because the Roosevelt literature has become so wealthy, so wide-ranging, and so voluminous that we're frankly having a challenge just keeping up with it. But we are certainly glad and privileged to have this group today to speak about FDR. You know that those of you who have been here before, and I see so many friends in the audience, that as part of our mission to provide civic engagement at Roosevelt House, we offer public programs focusing not only on public policy and human rights, but on FDR era and World War II history. And we will be doing so throughout the spring. So as I said, as we try to keep up, do stay tuned. And today, we have a real treat. Two amazing authors, three really, if we count our moderator, and we should, exploring two acclaimed, highly original new books on subjects that remain, as you'll hear, hot and newsworthy 80 years after the Roosevelt presidency. The tensions between the White House and Wall Street, and between the executive and the judiciary. And of course, the public response to each battle. These subjects are both timely and timeless at the same time. I always add that when FDR and his brain trust used this house as a presidential transition headquarters in late 1932 and early 1933. They had Wall Street very much on their minds as they devised their multi-pronged approach to the Great Depression. Perhaps they paid less attention at that fraught moment to the Supreme Court, or maybe our guests tonight will suggest otherwise, but obviously FDR turned his attention to the judiciary soon enough. So let's get to it. Just a few housekeeping notes. I hope all of you will please check anything in your bags or your pockets that make any kind of noise, and please turn it off so that it doesn't interrupt our proceedings. We want our guests on Zoom to have uninterrupted experiences here at Roosevelt House. So our conversation tonight will last about 45 minutes. Will be followed by an audience question and answer, during which we remind you to wait for the microphones so that our Zoom audience can hear as well as those in the house. And then we invite you all to join us at a reception and book signing upstairs. The authors will be inscribing their books. And here are our authors. Diana Henriques is the author of Taming the Street, The Old Guard, The New Deal, and FDR's Fight to Regulate American Capitalism, an account of how the president worked to both regulate and reform Wall Street and find a way to balance financial power and federal responsibility in the midst of what obviously was an existential financial crisis. The author of 5 previous books, including the Bernie Madoff bestseller that inspired the HBO movie starring Robert De Niro. That's important. Diana was on the staff of the New York Times for 23 years, has won many awards for her journalism, including a Goldsmith Prize from the Harvard Kennedy School. So welcome to Diana. Cliff Sloan is a widely published writer and commentator and a professor of constitutional law and criminal justice at Georgetown Law School. He has argued before the Supreme Court 7 different times at last count, and has served personally, professionally, in all 3 branches of government. His previous book is The Great Decision: Jefferson, Adams, Marshall, and the Battle for the Supreme Court. And the new book he is here to discuss is The Court at War: FDR, His Justices, and the World They Made. And he has been named today or yesterday as a finalist for the prestigious Silver Gavel Award for that book. Finally, we're delighted to welcome back to Roosevelt House the amazing Jonathan Alter, who for nearly 40 years was a senior editor at Newsweek, is a correspondent for NBC News, and a TV and film producer. He is the author of major books about both Jimmy Carter and Barack Obama, as well as the terrific volume that makes him the ideal interlocutor for this evening, The Defining Moment, FDR's 100 Days and the Triumph of Hope, which of course we featured here very soon after it came out. So please now join me in welcoming Diana Henriques and Cliff Sloan in conversation with Jonathan Alter.
Thank you, Harold. This is a great treat for me, not just being back here. I love this place, but I'm a great admirer of Diana. And Cliff, full disclosure, was my college roommate and sometime lawyer and very, very close friend. So anyway, I'm really glad to be here. We're going to divide this a little bit chronologically because Diana's story is basically about the 1930s, and Cliff's is basically about the 1940s. But Diana starts in the 20s, and Cliff's starts in the 30s. So just to kind of situate you a little bit chronologically, but I wanted to actually ask almost like a morale question to get us going. At the beginning of your book, you have a couple of quotes, one from Roosevelt and one from my longtime colleague and friend, John Meacham. And John's quote is, quote, "To know what comes before is to be armed against despair," unquote. So I know that when I was working on my Jimmy Carter book, anytime I needed a relief from Trump, I would just go back into my research and it cleansed me. So did you feel the same way about this?
Very much so. It was physically painful some days to emerge from the archives and the writing and the work and having my mind occupied by these figures, these characters, and to emerge from that into what we were going through. This was a 5-year project, so you can count back what we were all going through as I was going through this. And of course, the pandemic affected the research process in unpredictable and challenging ways. But I felt such inspiration in going back to the idealism, the sort of practical idealism that seemed to drive the early New Deal. Not perfect by any means, but still public-spirited, goodwill, concern for the general welfare. It was quite refreshing under the circumstances.
And Cliff, I saw you argue a case in the Supreme Court. I think you were already working on the book at the time. How do you feel about the relationship between historical research and fending off despair?
Well, I certainly agree with what you're both saying, that it's a sort of wonderful immersion in these times and personalities of creativity and idealism and pragmatism and all of those things. So I definitely also experienced that. At the same time, and to some extent, as I'm sure we will discuss with both of our subjects, we're really at a crossroads, and that is certainly true with the Supreme Court. And one of the things we'll talk about, I think, is that the very positive achievements of the Roosevelt Court in World War II provided a very firm foundation for the next 3/4 of a century on issues ranging from reproductive rights to voting rights to giving government broad flexibility and discretion and a wide berth in tackling complex problems. And all of those are under fire on today's court. And so while I really delighted in the immersion, it also put into relief for me very much the current crisis.
Yeah.
Okay, so since we're doing it chronologically, I'm going to start with Diana. Am I right in assuming that you wrote this book in part as a warning against what you called, quote, the unregulated capitalist paradise some conservatives are trying to reimpose on America? Unquote.
Yes, yes. I have been concerned about the political support for deregulation for most of my career as a financial journalist. You cover white-collar crime and you don't have any illusions about whether or not this market needs to be regulated. And I covered white-collar crime for nearly 50 years. So you know, I would kind of laugh it off, but over the past, certainly after Reagan, and then more assertively after George Bush, the political valence of deregulation seemed to get stronger and stronger and stronger. In his presidency, Trump bragged about, and the Brookings Institute agreed, that he had removed more regulations than any president in history. The one time we wish it were hyperbole, but it's not. It's actually true. So, yeah, I've been deeply concerned that two things were happening. There was this intensifying, libertarian-thrusted belief in getting rid of market regulation. You know, partly the Chicago School, the Milton Friedman, Eugene Fama ideas about unfettered markets, but also, you know, the primacy of finance as a driver of our economy. But you know, in addition to that coming about, we also are losing our memory of what it was like before. I mean, I had a young woman come up to me at one book signing, and she said, "I thought we'd always had an SEC. You know, like the founding fathers put it into the Bill of Rights or something. I don't know, but the idea that that Roosevelt's reforms have been part of our lives. You know, you don't fear your bank failing and you losing all your savings overnight because Roosevelt invented the FDIC. You know, the whole, we have all lived our lives and collected our fortunes to the degree that we could under the safety of that rule book. People had forgotten what the world was like before Roosevelt tackled Wall Street. And so there was that diminishing memory, and that was playing into the hands of those who wanted to distort and then dismantle the protections of the New Deal.
Can you tell us, you start with 4 characters. I want to ask you right now about 2 of them.
Okay.
Joe Kennedy and Richard Whitney. Now, I think some people know that Joe Kennedy was the first head of the SEC, but he's really a good guy in your book,
Yeah.
by and large. Why?
I do acknowledge all the ways in which he is not a good guy in history at large. And I refer to this as this isolated masterpiece of public service that he committed as chairman of the SEC. He was opportunistic, and I think compared certainly to many of the people who were helping to drive the New Deal, Kennedy saw the need for Roosevelt's reforms as a personal protection. He is quoted as saying, forgive me if it's not exact, but he said something like, these were days, this is the great days of the Great Depression with the rising social unrest. He said, these were days when I would have happily given half of what I owned to be able to enjoy the other half in peace and security. Because there was a perception, not just in his mind, that America was teetering on the edge of massive dislocations that would not be good for rich people like Joe Kennedy. And so to some degree, he was driven not by the kind of idealism we found elsewhere in the New Deal, but by personal protectiveness. Although he set a remarkable ethical standard at the SEC. He put all of his assets on hold for the entire time he was in office. Nothing could be sold or bought while he was in office, and established very high conflict of interest standards for the agency itself. He had a gift for taking dry language off a legislative page and turning it into not only a functional agency, but an extremely high morale excited, enterprising agency. One of the youngsters then who wound up as one of the gray heads of the SEC, who I was able to talk with, he said, "Oh, we all got to work early." He said, "We thought we were remaking the world." I mean, there was this sense that they were absolutely changing the way Wall Street had worked through their entire lives, all that they had known. So Joe Kennedy was the least reliable of Roosevelt's allies going forward, but when he needed him, when Roosevelt needed him, Kennedy came through for him.
So Roosevelt set the parameters to the ancient dictum, let the buyer beware. We had a new one for all time, let the seller beware.
Yes.
It's huge, huge conceptual
Absolutely.
shift. But he got help from two people in particular, Ferdinand Pecora and, ironically, Richard Whitney.
Yes.
So tell us about them.
He did. And, you know, Whitney was one of the most challenging and fascinating characters to deal with. The first president of the New York Stock Exchange to go to prison so far. He went to prison as an embezzler. He had been an embezzler the entire time he was mobilizing Wall Street's resistance to the New Deal. And yet, his influence helped shape significant pieces of SEC policy. The fact that short selling didn't die an early death in the first days of the New Deal is largely responsible to Richard Whitney. He was able to educate lawmakers, journalists, and bureaucrats about the role that short sales played in preserving market liquidity. So he had a tremendous influence. There were things that he was able to stop from happening that would have been very bad for market function. But most of all, when he got caught, he confessed everything. And that confession led to these stunning hearings that William O. Douglas held in 1938, examining how Richard Whitney had gotten away with his crimes for so long in this old boy club of the New York Stock Exchange. And that opened up to the entire public, and those hearings were followed rapidly across the country. They opened up to the whole public what a sucker's game it had been for the average investor, how the insiders really controlled it.
And this was in 38, right? So
Yes.
this short-circuited the counter-assault on the SEC.
It certainly helped.
Roosevelt's popularity was going down.
It was going
and
down,
Would they have been
and
able to kill or really gut
Douglas
the
thought
SEC?
so. Douglas thought so. There was a movement afoot called the Hamilton Committee, out of, again, the New York Stock Exchange, guy named John Hamilton, who had been working with the stock exchanges all across the country and had come to Washington that spring to negotiate some minor changes in the securities laws. Where let's eliminate the ban on market manipulation, or let's weaken the bans on insider trading. And Douglas looked at this and said, "Are you kidding me?" He was apoplectic when he saw these proposals, and then he is handed this gift by fate. And when I say the whole country was riveted by these, I quote in the book a sentencing hearing for a young man out in the Midwest, I think it was St. Louis, who had stolen $2 from a gas station. And the judge took out a piece of paper and pencil and calculated how much time in Sing Sing Richard Whitney had gotten for stealing $225,000 in cash, and then did the math and said, well, okay, for $2, your sentence is 24 minutes. He said there is not one law in this country for the rich and another for the poor. And so when I say that the country was riveted by it, it had a tremendous impact in reinforcing how important the work of the SEC was. So Richard Whitney, without intending to, probably gave Douglas an immunity booster to prevent the latest uprising of resistance from Wall Street.
And how about Ferdinand Pecora? How did he become a household name?
Pecora is one of the most fascinating guys to me. I can't let him loose. I mean, he's a Italian immigrant, came here when he was 4 years old. His parents were Episcopalians, so he had nothing to do with the Italian American community downtown. he had been a stellar district attorney here in New York City, assistant DA from 1918 to 1930, when he locked up too many Tammany Hall people and they wouldn't back him for election as DA. He was theatrical. When he was a kid attending St. Peter's Episcopal Church on West 20th Street, he was in the drama club, and he always dreamed of being. He memorized all the speeches in Julius Caesar. I mean, he was, and he had a prodigious, almost photographic memory. So he had this theatrical bent, and it had never quite clicked for him. I mean, the judges hearing cases out of the DA's office were not amused. They were not amused by the theatricality. But he gets to the Senate, and he gets there just by. I mean, it's almost like no one else would take the job. I mean, they'd gone through 3 general councils. One of them lasted 1 week.
And what year is this?
This is in 1933, so it's just it's just the months before Roosevelt's going to be sworn in. And the hearings have been disappointed. They've kind of sputtered since the fall of 32. Not much has been revealed. Richard Whitney played them like a violin, unbelievably impressive. Then, Pecora comes in. Senator Norbeck hires him. He thought that all that Pecora was going to do is write the final report for the committee's work because it was due when the Congress expired with the inauguration. That was not Pecora's plan. He started in his first week on the job. He sent subpoenas to Charlie Mitchell at National City Bank, now Citicorp, that would blow Mitchell out of his job when the hearings were finally held. He had found his moment. He had found his stage, and he rose to the shining hour. He was less effective as an SEC commissioner, but I think we can give him a pass on that.
So let's talk about another well-known figure, the Republican candidate for president in 1940, Wendell Willkie. I think a lot of people don't know that he was leading the charge on behalf of the utilities industry. And Roosevelt had been involved in the first regulation of public utilities as governor. Why is this whole question of regulating utilities so central to this story?
I'm so glad you asked that because it seemed bizarre to us now. We don't even think of public utilities as one of the 30 top important topics of the world. But at the time, Roosevelt, from his legislative career, understood that public utilities controlled the future. This was the dawn of the electric century. They were, to Roosevelt, what Silicon Valley is to us today. They had the technology and the wealth and the innovative power to shape the future of the economy. Where they ran power lines, economies would flourish, towns would grow. Where they didn't run power lines, you were out of luck. So Roosevelt thought that was too much power to be in private, profit-seeking hands. And he was determined that they would be brought under federal regulation. And it was one of the toughest fights, actually. This wasn't part of the 100 days, as you so beautifully wrote about, which saw the Banking Act and the 33 Act, the FDIC. This was a struggle, and he won in the end through sheer serendipity. I mean, you can always trust white-collar criminals to go too far. And in this case, they were on the brink of negotiating the conference committee in Congress, 2 distinctly different versions of the bill, when one of the worst black sheep of the utility industry gets caught. He gets caught having invented an entire AstroTurf campain.
Not Sam
No,
Wilson.
this is Henry Hobson, who was a New Yorker from upstate New York, and he'd hired people to go through phone books and cemeteries and get the names of people who sent telegrams to Congress to tell them that they opposed this bill. So that came out on the brink of this vote, and it was just enough to push it across.
And the Rural Electrification Administration, which was one of the big successes of
Yes.
the New Deal, and everything that Lyndon Johnson as a young man did in in bringing electrification to Texas. None of that would have been possible if they hadn't taken on
It would, and
utilities.
even more than that, it's very doubtful that the Manhattan Project could have been successful if he had not undertaken to regulate utilities. The Hanford facility, the Oak Ridge facility, Oak Ridge specifically, was driven by power that would not have been produced but for FDR. The cheap electricity that was essential to that research was an outgrowth of his regulation of the public utility holding companies. He gave a big boost to municipally owned power companies, which were essential to the Rural Electrification Act. So you're right, that all of that process of bringing power to the farms, 90% of the farms in the United States in 1932 did not have electricity. So they couldn't have electric pumps bringing their water up. They couldn't. They ate by gas, gas lamps. And so he was determined to change that, and did.
Changed Jimmy Carter's life. They didn't have any electricity until he was 11.
Changed my parents' life.
So as kind of a little bit of a transition to Cliff, I want you both to talk about William O. Douglas, and just give us a sense of, you've mentioned him in passing, but what kind of a guy was he? I mean, we're still reading about him because Bobby Kennedy Jr. became friends with him at the end of his life and traveled with him, and so this is a kind of an epic figure who spans both of your stories. Tell us about him in the 1930s.
Well, in the 1930s, he was a somewhat abrasive, eccentric law professor in 1930, a law professor at Harvard, at Yale rather. Grown up in in the West, in Washington State, had gone to a little bitty Whitman college, had bummed his way across the country on the rails and worked his way through Columbia Law School. Deeply ambitious and prodigiously intelligent. Again, a near photographic memory that he would embroider on quite carefully. But he had served. He seemed to be set on the corporate law path when he came out of Columbia. Went to work for a white shoe Wall Street firm. Participated actually in one of the most scandalous bankruptcy railroad reorganizations of that era, and seemed to be going to become and it didn't fit. He could not fit into that world. So in my telling, he is sort of the misfit, the sidekick to FDR, who rides with him to the end of the trail, forever loyal, but cracking jokes and playing poker and drinking a little too much, and very much the all shucks guy who reveled in thumbing his nose at Wall Street. I mean, he and Richard Whitney were like lighter fluid and lighter fluid and a match.
And was it Jerome Frank, who you describe as kind of like the Yale Law School version of what Felix Frankfurter did with Felix's hot dogs at Harvard Law School?
And Jerome Frank followed Douglas as chairman of the SEC. Is he
the one who brought Douglas into the
No,
New Deal?
Joe Kennedy brought Douglas in to the SEC. Part of the bill that created the SEC required a study of bankruptcy practices, because there had been endless scandals in the production of in bankruptcy cases, corporate bankruptcies, of which there were a great number by the end as the Depression ground on. And so Joe Kennedy had the job of getting this bankruptcy study done. It was mandated by Congress in the Creative Act. He asked Jim Landis, another of the original commissioners, who do we get? And although Landis and Douglas were like chalk and cheese, they never got along very well, Landis knew that Douglas was the best expert on corporate bankruptcy in the country, and he brought him down to D.C.
So there's a lot more about Douglas, and there's a lot of great stuff about Douglas in your book. And just to give you a little teaser of what's going to come, he was Franklin Roosevelt's choice to be his successor as president in 1944. Franklin Roosevelt only lived for, a couple of months into his fourth term, so things had gone a little differently. William O. Douglas would have been Harry Truman. But before we get to that, set up the court for us after Pearl Harbor. So by 1941, 7 of the 9 justices had been appointed by Franklin Roosevelt. And what happened to those justices after Pearl Harbor is just a fascinating story. So tick through some of them and what happened.
Sure, and the point that John was just making is very important. Everybody is sort of generally familiar with FDR's failed court packing plan in 1937, and then the switch in time that saved 9, where one of the justices, Owen Roberts, was perceived to change his votes to now allow the upholding of New Deal legislation and progressive legislation in states. But one thing that is not well known is this point that John just made, that by the summer of 1941, due to a wave of deaths and resignations, FDR had appointed 7 of the 9 and elevated an 8th, Harlan Fiske Stone, to be Chief Justice. There was only one justice on the court, Owen Roberts, who didn't know his position to FDR. It was by far the biggest impact on the Supreme Court of any president since George Washington. So that's in the summer of 1941, the Roosevelt court really takes hold. And then there is Pearl Harbor. But even in 1941, leading up to Pearl Harbor, to a very unusual degree, and this was a real revelation to me as I was working on it, the justices were very active supporting FDR's policy goals, and particularly preparedness, at a time when, as you know, there was a very strong isolationist sentiment in the country. And we talk about the number of justices, and it wasn't just how many there were, although it's an astonishing number. They were almost all extremely close to FDR, including Douglas, and we'll talk about that in a minute. But they were out on the hustings giving speeches saying, we need to support the president in this policy. And these are given huge coverage in the newspapers, and not a word about the possible impropriety of a Supreme Court justice out there, on these policy issues. And then that dramatically intensified in the wake of Pearl Harbor. And again, throughout the war years, the justices are out there with public advocacy. They take on formal and informal assignments for FDR. And I'll tell you 2 brief anecdotes that I think really illustrate it. And one is told to me by a gentleman who just turned 100 years old. And he was 17 at the time of Pearl Harbor. And he was working as a library aide in the Supreme Court. And so Monday, December 8th, in the morning, he's doing what a library aide does. He's dropping off books, he's picking up books, and suddenly he sees through the front door these heavily armed U.S. soldiers come bursting in and take up positions at the Supreme Court, at the windows, at the doors, on the roof. And the reason was because FDR was going to be speaking to Congress in a joint session at noon. This is a famous day of infamy speech. And actually, the justices adjourned court, so they went and they were in the front row. And so this was part of this expanded security perimeter around the Capitol. This is less than 24 hours after Pearl Harbor. But what you see, quite literally, is the war invading the quiet precincts of the Supreme Court. And the second anecdote is a few days after Christmas, in December 1941, Winston Churchill has come to Washington in a dramatic surprise visit, and he's staying at the White House. And again, he's addressing a joint session of Congress, and all the justices are in the front row. And he gives this rousing, eloquent Churchillian speech, and he finishes and he looks out at the crowd, and he lifts his fingers in his trademark V for Victory sign. And in the front row very prominently, the Chief Justice, Harlan Fiske Stone, lifts his fingers in a V for Victory sign in response. And that is reported in newspapers throughout the country. And again, the message was clear. The court was in the fight. But let's talk a little bit about Douglas in particular, because he exemplifies some of the issues and actually some of the problems of FDR's relationships with the justices. Now, as Diana was saying, FDR and Douglas were very close. FDR was very fond of Douglas. He was part of his poker circle. He talked about what great stories Douglas told. He also always said, and this was very important to FDR, that Douglas made the best martini of anybody in Washington. And of course, Douglas had this meteoric rise, as we were hearing, as chair of the SEC. And FDR put him on the Supreme Court in 1939 when he was only 40 years old. And he was FDR's fourth appointment. And throughout his time on the court, while FDR was alive, they were very close, getting together all the time. And in 1944, when FDR had decided to sack Henry Wallace as his vice president, and the question was who should be his running mate. And FDR very much favored Douglas. He thought Douglas would have a great political profile. His modest upbringing in Washington State, his image as an outdoorsman. FDR was actually a little infatuated with Douglas. He talked about how his hair blew in the wind. And so he told his advisors, he gets together with his political advisors one night at the White House in the summer of 1944. And he says, I really want Douglas. I think he's the guy to be the running mate. And the political aides were very skeptical because, first of all, Douglas had never run for office. The head of the Democratic National Committee was from Missouri, and he was very close to Harry Truman. So they're all pushing Truman. And so FDR was kind of non-committal, not unusual for FDR. And he officially decided that he was going to leave it up to the convention to decide. He wasn't going to select his running mate. But the week of the convention, he released a letter saying he would be very happy to have either Harry Truman or William O. Douglas as his running mate. They were the only two people mentioned in the letter. And the press at the time was featuring Douglas, who's a sitting Supreme Court justice, as one of the leading candidates to be vice president, and in some accounts as the leading candidate. Douglas himself did not go to the convention in Chicago, but there were a group of people working very hard on his behalf around the clock in Chicago, trying to get the nomination for him. And really, up until the very last day, it was seen as very possible, if not likely, that Douglas was going to get the nomination. And as John was saying, he would have then been FDR's successor.
So there was another Supreme Court Justice, Jimmy Burns, who was also on the short list for vice president. It's an amazing story of what happened in 1944. There's only one candidate who ever came directly from the Supreme Court to a ticket, and that was Charles Evans Hughes in 1916, ran against Woodrow Wilson. But it's kind of unimaginable now, the idea of Supreme Court justices, being directly involved. I mean, we have the wife of a Supreme Court justice involved in politics, but to have the justices themselves directly involved. But that's partly because they had different backgrounds. That, like, Hugo Black came from the Senate, and tell us about, I want to back up a little, back to 1941 and 42. There were three justices who left the court on temporary assignment to do things, or they didn't leave the court, but they did things outside of the court for the war effort. So who were they and what did they do?
Right. Well, as I was mentioning, there were these both formal and informal assignments of the justices. And so one of them, a formal assignment, and he did leave the court, was Owen Roberts shortly after Pearl Harbor. And again, Roberts was the only one on the court who FDR had not put in his current position, but he had also been the switch in time that saved 9. And so in the wake of Pearl Harbor, and partly to head off congressional investigations, FDR appointed a commission to investigate what happened at Pearl Harbor. How could this have happened? How was there this lack of preparedness? And so he appointed Owen Roberts to head the commission. Everybody else on the commission were generals and admirals, and Roberts took a 2-month leave from the court, which the Chief Justice Harlan Fiske Stone wasn't very happy about, and he went to Hawaii with the generals and admirals, and they interviewed lots of people behind closed doors. They also had public hearings there, and they came back, and Roberts met one-on-one with FDR for several hours, gave him the commission's report. FDR immediately released it to the press. Roberts also came back and met privately with Secretary of War Henry Stimson. But here was this very prominent formal assignment. And it had one very unfortunate consequence, because some of the things in the Roberts Commission report were then immediately seized on the West Coast as a justification for incarceration, or people a lot of times refer to it as internment.
Since you brought that up, I want to. I was going to go through some of the good decisions that they made. We'll get to those, but since you brought up the Japanese internment camps, let's talk about Korematsu and Endo. Who were Fred Korematsu and Mitsuye Endo, and how did I think people are sort of vaguely familiar with the Korematsu decision, but they don't know anything about the Endo case. So if you could just quickly, in the interest of time, give us the short version of those two extremely important cases.
Sure. So Korematsu, Fred Korematsu was challenging his expulsion from his home and his incarceration. And even a year earlier, there was a case, Hirabayashi, where the Supreme Court had upheld a criminal curfew targeted only at Japanese Americans. And the court had said it wasn't getting into the question of the internment camps, but it upheld the criminal curfew. And so in Korematsu, and of course this all flows from an executive order that FDR issued in February 1943 in response to a huge political uproar and pressure from the Western states, and there were people at the War Department, very high levels, like John J. McCloy, for example, who were pushing hard for this incarceration policy, expulsion and incarceration. And the Supreme Court ultimately, in a 6-3 decision by former Senator Justice Hugo Black, upheld the policy. And there were 3 justices who dissented: Robert Jackson, and then who's very well known, and 2 who are not that well known, Frank Murphy and Owen Roberts. And Frank Murphy, he had been the governor of Michigan, the mayor of Detroit. He said the court has fallen into the abyss of racism, and that sort of stung Black. And in his majority opinion, he emphatically rejected that it was racism.
He was a former KKK member himself.
Yes, he was, and there was a huge controversy. But, you know, interestingly, in a lot of other areas, and maybe in response to the KKK controversy, Black had actually become a champion in a lot of contexts of civil liberties and civil rights. But on this issue, he just sort of said, well, war has a lot of hardships. And, you know, one of the things that's also important, I'll just say very briefly, the justices themselves were dealing with the war on a daily basis. 5 of them, including Hugo Black, had sons in the military. A 6th had a son-in-law in the military. Frank Murphy actually secured an assignment in the military for a few months while he was on the Supreme Court. And
In uniform.
yeah, I mean, he was, and there were newsreels of him with weapons that were shown in all the movie theaters with him in tanks and in his military uniform. But Black's wife, prompted in large part by her worry over their 2 sons in the military, suffered terrible depression during the war. She would stay in her room for weeks on end. She was inconsolable. And so this is all sort of part of the backdrop as Black is writing this opinion and saying that, you know, war is a series of hardships. Korematsu is frequently, completely appropriately talked about, as I'm sure you know, as one of the very worst decisions the Supreme Court has ever issued, up there with Dred Scott and Plessy versus Ferguson. I think that's entirely accurate. And so Korematsu lost his case. But there was a companion case, which which is fairly unknown. There was a woman, Mitsue Endo, and she had been expelled from her home with her family. She was 22 years old and incarcerated. And the military had made a determination with her that she posed no security threat. And yet they continued to want to incarcerate her. And they actually offered, well, we'll let you go if you promise you won't go to the West Coast. But she felt very strongly about continuing the case. And actually, in that case, the Supreme Court said, well, if the military has made the determination that somebody's not a security threat, there's no statutory authority to hold somebody. And that directly led to, in December 1944, the decision to end the incarceration unless people were determined to be security threats. Now, the military had already been moving in that direction, and the government had been, and very shamefully, you know, FDR had resisted efforts, including by the War Department, to do it earlier in 1944, because he didn't want to do it until after the presidential election, because he was concerned about political consequences on the West Coast. Absolutely shameful on FDR's part. And one other thing that I just do want to mention on this, just very briefly, one of the things that has come out since then, since the cases, is that the US government, the Justice Department and the War Department, had in its possession evidence that directly contradicted, directly belied their claims to the US Supreme Court about the national security threat. And they made a deliberate decision, and again, this was spearheaded by John J. McCloy, they made a deliberate decision not to submit that to the Supreme Court. Now, none of that gets the Supreme Court off the hook, but it's really very much a very important cautionary tale about the dangers of excessive deference to the government when it's invoking national security as the justification.
Just very briefly, before we open up for questions, there were some good decisions that the court made in this period that surprised me when I read about them. Give a couple examples.
So it's really a tale of two courts. It's the best of courts and the worst of courts, and they both relate to the war fundamentally. So the worst of courts, we were just talking about these incarceration decisions, and there's one involving Nazi saboteurs as well. But on the best of courts side, in a series of decisions, the court in very self-conscious contrast to the authoritarians, to the fascists, to the totalitarians, to the Nazis, recognized and expanded civil liberties. This is what makes us different from them. And so it struck down a forced sterilization law from Oklahoma, which is the first time that the Supreme Court was recognizing the decision about whether to have a child, reproductive rights, as a fundamental liberty interest. And it was very much in the context where everybody knew Hitler and the Nazis were engaged in this massive forced sterilization program. There was a very famous First Amendment decision at the height of the war by Justice Robert Jackson, striking down a mandatory flag salute that West Virginia had adopted in its public schools in the wake of Pearl Harbor. Jackson said, that's what they do. They try to compel unity. In our system of government, in our constitutional democracy, no government official can tell you what you have to think and believe. And in voting rights, during World War II, Thurgood Marshall argues his first cases in the Supreme Court, and his first big victory is striking down the all-white primary in Texas and throughout the South. And again, very much a part of the context of the case and the press coverage of it, that we were fighting a regime that's premised on racial supremacy. And there was a lot going on in terms of civil rights activity and civil rights ferment. The African American community had adopted what are called the Double V campaign, victory over fascism abroad and racism at home. And that was all very much part of the context of these decisions. But the court was clearly drawing a contrast and thought that was very important with the regimes that we were fighting.
Black and Douglas were still on the court in the Warren years. So you argue that these decisions helped set the table for the great victories of the Warren court?
Oh, absolutely. I mean, there's no question that it did. I mean, that the decision striking down the all-white primaries, for example, the one historian says that launches a trajectory that culminates 10 years later in Brown versus Board of Education. And of course, full voting rights wouldn't be accomplished until the efforts of very courageous citizen activists and the passage of the Voting Rights Act in 1965. But this decision from World War II, a very important foundational case. And the forced sterilization case, Skinner versus Oklahoma, is cited and relied on in reproductive rights decisions, including Roe versus Wade, cited and relied on in the decision striking down the ban on interracial marriage in Loving versus Virginia, cited and relied on in the same-sex marriage decision, Obergefell. And in the Dobbs decision overruling Roe versus Wade, the dissenters point to Skinner as one of the landmark decisions that they think that the analysis and reasoning of the majority now threatens. So all of these were, very, very important sort of foundational decisions.
Great. I think both of these books really, they don't just emphasize that, as a great Dutch historian said, history is an argument without end. They also emphasize the kind of sedimentary nature of our history, and really all history, that what's happening now is very much connected. So this Project 2025, the deep state analysis that the Heritage Foundation has in their report, where they basically want to repeal all of this, right?
Yeah.
Everything that you talk about.
I've read the sections of the Heritage 2025 project that relate to the financial regulatory agencies, the independent agencies. Mm-hmm. And it would have curled my hair if I were so prone. There is a political juggernaut aimed at the regulatory architecture that was built up from the New Deal. But there is a judicial assault as well. There are cases that are moving themselves through a court system that over the decades has been tilted. You're the expert on this, but it seems to me has been tilted more and more in a pro-business, anti-regulatory direction. And so these cases are finding their way through. Dr. Joel Seligman, the monumental historian of the SEC, in his book, The Transformation of Wall Street, he did a law review article last summer where he said that the regulatory state, the administrative agencies, are under judicial assault on a scale that we have not seen before. This term, the Supreme Court will decide a case called SEC v. Jarkizi, financier in Texas, accused of violating the 33 Act, lying to investors about what he was doing. It doesn't get more basic than that. And he has appealed and won at the Fifth Circuit on the grounds that he's entitled to a jury trial, that the SEC cannot proceed with these civil penalties through the administrative law process. Now, there are two other grounds on which he's appealing, but if the Fifth Circuit is not overturned by the Supreme Court, the enforcement actions of the SEC will be kneecapped. They will be unable to bring any sort of realistic enforcement measures if they have to go. There aren't enough judges. There just aren't enough courts.
No.
So
Yeah, absolutely. And just very briefly, it's a very important issue, and it's where our books really kind of come together because the issue that united the post-1937 court and the Roosevelt justices, who had feuds on some issues and who had some personal feuds as well, but the issue that united them the most was giving the government this broad authority to deal with complex social problems. That was the sort of fundamental issue. And that's the regime we've been living under since. But as Diana was saying, you know, really in the past 15 years or so, and now really accelerating, the court is extremely hostile to the regulatory state, to the administrative state, to agency actions. It's coming up with brand new doctrines like this major question doctrine that the court has just announced in the last couple of years, which has been used to throw out government actions ranging from COVID response to climate change. It's reviving doctrines that haven't been used since before 1937. One example is the non-delegation doctrines, that there are all sorts of very strict limits on what Congress can delegate to agencies. There's a case that has been there for decades called the Chevron case, which means courts should defer to agencies' expert judgments unless it's unreasonable. The court seems poised to overrule the Chevron doctrine and say, no, we're not going to defer. It's going to be up to courts whether we think these complex regulations are a good idea or not. So it's just on all fronts, there's this sort of frontal assault, including with financial regulators.
well, and the financial regulatory decisions could have cataclysmic overnight decisions. There's a case working through the D.C. Circuit Court of Appeals called Alpine Securities versus FINRA. FINRA is a direct descendant of the Maloney Act of 1938 that was one of the last of the financial reforms, along with the 40 Acts, which regulate the mutual fund industry, that FDR signed before the war pulled him away from that agenda of reform. And so the FINRA is the direct descendant of the NASD's regulatory arm. And
So-
this case it seeks to have it declared unconstitutional,
So
lock, stock, and barrel.
The New Deal could be repealed even if Biden wins.
Yes, it
so
could be.
with that happy thought, let's see your questions. We have a little bit of time for your questions. We've got about 10 minutes. Yes, right over there.
Wait for them.
Hi, Albert Knapp, NYU School of Medicine. I have a question for Ms. Enriquez. You mentioned deregulation and you cited Bush Jr. and Reagan. I think there's blame on the other side, and since Clinton gutted Glass-Steagall and also wrecked Fannie Mae and Freddie Mac.
You're absolutely right. Deregulation has been given lip service by both political parties, which is when it really starts to get scary. That's changing now. I mean, it has changed in the last 8 to 12 years. Obama came in on the heels of the great financial meltdown. I mean, he had Bernie Madoff, you know, in court when he was being sworn in. So the tolerance for deregulation on the financial enforcement side began to ebb at that point. But you're absolutely right. This has been a long project of the opponents to financial regulation, and they have found allies on all sides of the political table.
Yes, back there in the red shirt.
You talked about Justice Jackson's opinion about not having to salute the flag. How do you reconcile that decision with the fact that even in the 1960s, kids were taking a Pledge of Allegiance to the flag? How is that not inconsistent with that decision?
Well, that decision allowed Jehovah's Witnesses not to participate in the flag salute. So it was allowing dissenters not to participate. He wasn't saying that the flag salute couldn't be done in the schools. But Jehovah's Witnesses, who were at the time a very despised and reviled and persecuted religious minority, thought it was saluting to a graven image. So he was allowing them to basically opt out, and because they were being suspended from school and that kind of thing. But he wasn't striking down the flag salute. He was striking down the mandatory aspect of it.
Yes, right there.
My name is Mr. Rao. Very simple question. Thank you for your historical illumination, which I was ignorant. My question straightforward is, you said in the 30s there was that racial supremacy promoted by the packed court. Now we have another packed court here, Roberts Court. If there is that kind of racial supremacy going on, and how far it would go with this present
I
court?
think that we have similar problems with the court and its public legitimacy now.
Let's see. I think in terms of substantively, my own personal view, is that this Supreme Court is getting a lot of fundamental issues very, very wrong. And sort of to your point, in the wake of the 1937 and then the Constitutional Revolution, when there was a switch in time and the court wasn't striking down all of these statutes anymore, there's a very famous footnote in an opinion by then Justice Harlan Fiske Stone in a case called Caroline Products, where they're trying to figure out what is the role of the Supreme Court. And he says that on issues about the economy and regulation and public health, it should be very, very deferential to the political actors. But if there is exclusion of people from the political process, if there's oppression or persecution of, this phrase is discrete and insular minorities, then the court has a special role to protect them, okay? And so that's sort of his famous formulation. Now, my own view, I think that basically kind of gets it right. And the current Supreme Court is doing the opposite. On economic and regulatory issues, it's very, very intrusive. And on many issues, including protecting voting rights and including protecting reproductive rights, on a whole series of issues there, it's completely pulling back protection. So I think it's a very, very major problem for us right now. Absolutely, I completely agree with you.
Yes. Sorry, the mic is a little ways away.
Hi, I'm Dan. I'm Dan Feld. Could you speak, Professor Sloan? Could you speak briefly a little bit about Felix Frankfurter and his role in the Roosevelt Court?
Glad you brought that up.
Sure. So, one of the things that's very, very interesting is that you have all of these justices appointed, and they're all very close to FDR, including, of course, Frankfurter. And, FDR, and he had been, they first got to know each other during World War I. Frankfurter had been advising him when he was governor and throughout the 30s. FDR one time said that Felix Frankfurter has more ideas per minute than anybody I know, and I love it, And Frankfurter is constantly meeting with FDR, sending him suggestions and that kind of thing. But you have all of these FDR appointees, but then contrary to public expectation and contrary to the predictions of pundits, they did not act in unison and they did not march in lockstep. Very far from it. They quickly devolved into two blocks. Frankfurter and Jackson were in one block, along with Owen Roberts and Stanley Reed, and Black and Douglas and Frank Murphy and Wiley Rutledge were in another block. Now, some of it was substantive because Frankfurter, sort of scarred by the pre-1937 court striking down all this legislation, tended to take a hands-off approach, and Black, who was really taking what he viewed as a plain reading approach to the Supreme Court, but it was leading him, to the Constitution, a plain reading approach to the Constitution, but it was leading him to very different places than modern textualists. It was leading him to sort of broad guarantees of civil rights and civil liberties. And so there are some substantive clashes. But part of it was also very much personal. And, we talked about the fact that almost all these justices, in contrast to today's court, where almost all of them were federal appellate judges, even former senators, former attorneys general, former head of the SEC, former leading public intellectual, and maybe partly because they had these broad public backgrounds, each of them felt that he could and should be leading the court. None more so than Felix Frankfurter. Frankfurter had been writing about the court for many years. He was this prominent Harvard law professor. He was very close to iconic figures like Oliver Wendell Holmes and Louis Brandeis. And he thought it was his natural fate and destiny to be leading the court, and the other justices would just fall in line behind him.
And he also played a critical role in the creation of the financial reforms.
Yes,
I mean, he
yeah.
had, to the extent that FDR thought of his financial reforms as the heart and soul of the New Deal, well, who sent the three little protégés down to
Yes.
Washington
Yeah, right.
to write the 33 and 34
Felix
Acts?
Hot Dogs.
Felix Frankfurter.
Yeah.
Felix is happy
Happy hot
His
dogs.
Happy
Yeah,
Hot Dogs.
Yeah.
That is-
Jim Landis, Benjamin Cohen, and Tommy Corcoran.
Right.
They drafted this incredible, court-proof legislation which faced its test in 1937. So Felix had been pulling strings in the New Deal from before.
Oh, and
there
he
was a
had
New Deal.
people like that throughout the government,
Yeah.
actually including McCloy. He was very close to McCloy. McCloy had been a student of his, and they would go for walks in Georgetown together every night. But Frankfurter was so upset that the other justices weren't falling in line behind him that he kept a diary during a lot of the war years, and in it he records every insult and grievance and slight by Black and Douglas and Murphy, and he even took to calling them the Axis. Now, this is at the height of World War II when we're fighting these Axis countries. It's as though after 9/11, one justice started calling other justices Al-Qaeda. And it wasn't a one-way street, because there are notes from Douglas to Murphy in this period where he refers to Frankfurter as der Führer and the little bastard.
So on that note, we are going to adjourn, and there's a reception awaiting us and book signing.